Good afternoon and welcome to those of you that have joined. We've just opened the link, so we're just going to wait for a few minutes to allow everybody to join before we start. Welcome to those of you that have joined. We have just opened the live link, so we're just waiting for a few minutes to allow everybody to join before we start. Welcome to the Five Stone Buildings webinar program. We have just opened the live link, so we're just waiting for a few minutes to allow everybody to join before we start. Whilst we are waiting for everybody to join, I shall just remind you of the house rules. Just to let you know that this webinar is being recorded. If you have any questions throughout this webinar, please put your questions into the Q&A box at the bottom of your screen, and our speakers will try to come to the questions at the end if we have time. If you do not wish to be identified when asking your question, then please tick the anonymous box so that our speakers do not identify you in their response. And just to remind you that we now have a webinar section on the Five Stone Buildings website, where you will be able to find a copy of this recording and the slides used during this presentation and all previous webinars. I will now hand over to Barbara Rich.
Hello everybody and welcome to, I understand, a very large number of you joining us, and we're delighted that you have, and that, as it happens, Jordan and I were adversaries in this case, so we can bring you between us, I hope, a first-hand view and a fresh view of the judgment that was handed down really exactly a week ago, midday last Friday, in Miles against Shearer. And I should say that although we can give you that, as it were, insider's view from having conducted the trial, there are limits on that because there's a pending application for permission to appeal. And of course, there are matters which are confidential and privileged as between our respective clients that we can't touch on, however tempting it might be. So I just wanted to mention that as a preliminary. As you may be aware, this case not only interesting, and of course our focus on it today is as legal practitioners with wide experience in this area, in Inheritance Act claims generally, and in what has had a different topical focus since Eilert and Mitson in 2017, claims brought by adult children. But it won't have escaped your attention that this case also received coverage in the news in what we certainly in the basement at Five Stone Buildings in the days when we used to go to work there, referred to as the Daily Mail law reports. And one thing that struck me in both the Daily Mail and the Times gave the case quite a lot of coverage both at the hearing and in the judgment, is that the journalist failed to spot one really quite endearing and interesting fact about the late Tony Shearer, which was that he'd changed his middle name to Presley as an act of homage to the king, and had indeed been to Graceland a number of times in his life. So there's a streak in his personality which was not perhaps that of the conventional chartered accountant and chief executive of a merchant bank, and I'm slightly surprised that the press didn't pick that up. Anyway, that's enough from me for now. Jordan's going to talk about the case, and then between us, as the slides will show, we're going to discuss various facets of it and welcome questions and answers at the end.
Thanks, Barbara. Yeah, and thank you everyone for joining us. So as Barbara said, there is a pending application for permission to appeal, and I'm acting for the claimants who were unsuccessful, and therefore I'm quite constrained in terms of expressing any opinion or anything like that. Barbara, who won, may be able to express considerably more. But just to give you an introduction then to the facts of the case, the claimants who were my clients were the adult daughters of Tony, who, as Barbara said, was something of an Elvis fanatic and had changed his middle name to Anthony Presley. Changed his middle name to Presley so that he was Anthony Presley Shearer. He regrettably died on only 68 on the 12th of October 2017 from an aggressive brain tumour. In 2017, he divorced my client's, sorry, 2007, yeah, 2007, he divorced my client's mother, Jennifer, after a marriage of 34 years. My clients were the only children of that marriage. And shortly thereafter, he married Barbara's client, Pamela, who was the defendant. His will was from the 2nd of February 2015. And I've put in brackets that it was a mirror will with the defendant. That is, for those of you who read the judgment, you'll see that was relevant because it formed the basis of some of the arguments which we had in the trial. The will was, the defendant was the executor and essentially the sole beneficiary. There were two small legacies of £5,000 to one group of friends and £5,000 to a different group of friends to hold a kind of dinner / knees up in the deceased's honour. But other than that, it was everything to Pamela. There was no provision for my clients, the claimants. There was the substitutionary provisions, which were the same in both mirror wills, obviously, were that after the death of the survivor, essentially, the estate would be split as to 50% between two of the defendant's friends, and as to 50%, well, as to 25% to one of my clients, and as to 25% to that client's children, so the older daughter, Juliet. Loretta, the younger daughter, who at the time of making the will in 2015, was not estranged, but certainly experiencing difficulties in her relationship with the deceased, was not included in even the substitutionary provisions. Now, the estate was sworn at 2.2 million. I think the estate accounts, it was about 2.5 million after administration. There was more wealth outside the estate. There was some jointly owned property, and there were also other assets like pensions, etc., that fell outside the estate and therefore not part of the estate for the purposes of the 1975 Act. So my clients then applied for an order for reasonable financial provision under section 1C as children of the deceased. A quick background, as it were, all of this is in the judgment, but Tony was from a comfortably well off, I think is how the judge put it, background. He was privately educated, he had a pretty expensive gap year, that kind of thing. He then went into the city and he worked in finance until the end of his career. His last big role, after this there was some non-executive directorships, but his last big role and the pinnacle of his career, as it were, was CEO of Singer and Friedlander in 2005. Regrettably, shortly after being appointed, he discovered that there was a takeover attempt from what everyone just refers to as the Icelanders, and he kind of discovered various different things about that, which he was eventually proved right. But as a result, he had to resign because he was not in favour of the takeover, and so that was basically the pinnacle of his career. That affected him quite a lot. That was 2006, so he hadn't been CEO for a long time, and it was at that time that his marriage to Jennifer broke down, or certainly the ending began to be formalised, and he commenced a relationship with Pamela. My clients, given his financial circumstances, they were also raised in a similar background to the deceased. They had a large house in Holland Park. They were privately educated. They also had gap years funded, that kind of solidly upper middle class lifestyle. On the breakdown of the marriage, or the finalisation of the divorce of the marriage, Jennifer received approximately 50-50. There there were things said in the evidence about the extent to which it was in fact 50-50, but I don't think anyone was seriously alleging that it didn't equate to about 50-50, although some of the shares that she accepted hadn't done very well, and so in the end she said it was less than 50-50, but it wasn't. It was roughly 50-50.
And it wasn't sorry to interrupt, but it wasn't a disputed divorce. It wasn't one of these protracted trench warfare kind of things, which quite often happen in big money divorces.
No, and the relationship, I think nobody questioned the fact that the relationship between Jennifer and Tony remained good throughout.
They were on civil terms.
And yes, so Tony and Pamela married in 2007, and before that happened, largely as a result of the breakdown between Jennifer and Tony's marriage, the relationship between the claimants and the deceased became pretty strained, and that continued at various different points throughout the rest of the deceased life. There were various different flare-ups to that, some of which were focused on in the trial. In particular, the youngest daughter's marriage and relationship was a big source of friction. Tony did not like him and believed him to be threatening him, etc. And so that caused a lot, essentially an almost total breakdown in the relationship, until she divorced him, or began the process of divorcing him, separated from him in about 2015. And then after that, that they began to talk, etc. again, and that there was some rapprochement. The relationship it was slightly different way round, as it were, in that the relationship between the older daughter, Juliet, and Tony was more difficult at the beginning of the breakdown, and became better afterwards. And indeed, in Tony's last illness, despite there having been problems between Pamela and Juliet, at first they appeared, certainly on the face of it, to have had quite a good relationship. The presentation of the checks, which I've put there, this was a central event in the narrative, which formed quite a large part of the judgment. So this was disputed. My clients disputed that there was any kind of in-person meeting or anything, but essentially what was said, which was found to be accurate, is that in 2008 there was an in-person meeting, and at that meeting, Juliet, the eldest daughter, was given £177,000, and Loretta, the younger daughter, was given £185,000. Now those sums derived from the sale of a flat, which was by that point in the joint names following the divorce, had previously been held. Well, the beneficial interest had been held, or the main part of it, the part that we're dealing with, had been held in Tony's sole name. After the divorce, it was the joint names of Tony and Jennifer, but they'd always, or certainly at this point, they knew that they were going to sell it, and those sums were to be held for Juliet and Loretta. Now there was a dispute, essentially, as to whether or not Juliet and Loretta already owned those sums, but in the end the judge said that didn't matter, because if they did, he wasn't prepared to accept that there was any realistic possibility other than that they derived from Tony. And so essentially he said, oh, you should use these and invest in property, which is what they did, and said, this is the last you're ever going to get from me. You should consider this my last gift to you, and my financial obligations are at an end. He wrote some letters to the claimants in terms which were disputed, but which the judge found he had meant to say, and did say, that his financial obligations were at an end, and it was not disputed in any event, that after 2008 he didn't provide any financial assistance to either of the claimants. So then by the time we got to trial, the older claimant's, the older daughter's position was that she had two daughters. Her younger daughter was severely autistic, as a result of which she hadn't worked for some time, although in fact she hadn't worked since the birth of the older daughter in any event. She was in the process of divorcing her second husband. He wasn't the father of her children. That was her first husband, who she divorced some time ago. Since 2017, she'd been living with Jennifer in a large, well-appointed house in the country, which had a pool and 5 bedrooms, etc. And one of the reasons that Jennifer had specifically bought that to set up a joint household, because it would be particularly beneficial for the younger daughter, who was severely autistic. She also had capital of about £175,000. That was currently invested in a flat, which was jointly owned with Jennifer. However, there was some dispute about whether she actually had double that amount of money in the flat. But in the end, what the judge said was, if she didn't have that double that amount of money, then Jennifer was going to, if she didn't already have it, then Jennifer was going to give it to her. So essentially, her capital wasn't £175,000. It was over £300,000. The younger claimant's position was slightly different. She had one son. She was divorced. Her son was very young. She works at an auction house, earning £70,000 per year. She had capital in her flat of £300,000, or roughly £300,000. Again, the values were open to question at trial, but her flat was basically held on an interest-only mortgage because she didn't have sufficient equity or earning capacity to switch to a repayment mortgage. And part of the equity in her flat, not the £300,000, an extra bit of equity in the flat, was retained by her ex-husband. He could only call for that, i.e. by calling for an order for sale or to be bought out. He could only call for that when their son became 18, which was would have been 2034, roughly. So, right. So the claim then, what the eldest daughter sought was a housing fund, which she proposed to use to purchase property outright with her £177,000 capital. She sought the cost of retraining. She wanted to retrain as a dog behaviourist and trainer. And she also sought a Duxbury sum. The younger claimant sought a sum to allow her to switch to a repayment mortgage, and a sum to buy her ex-husband out of the flat that she shared with her son. The combined value of their claims was just over just under, I think, £1.2 million. Pamela opposed this. She didn't run a need-based defence. She didn't say that she needed the money for herself. Her claim was that the claimants couldn't establish that they in fact had any needs that needed to be met from the estate. But even if they could, their conduct towards the deceased and the fact that there was no continued assumption of responsibility towards them by the deceased meant that they shouldn't be awarded anything from the estate. Pamela was successful at trial. The claims were dismissed. The basis of the judgment, in terms of needs, is that the older claimant, Juliet, couldn't establish a need for maintenance. It was likely that her mother would allow her the further £177,000 from the joint flat on sale, if indeed she hadn't already done that. That there were realistic housing alternatives, even if her mother sold the shared house, either by them all continuing to live in the country, them all continuing to live in London, or there was a third option whereby they split their household, but it was still realistic for Juliet to obtain a property outright. It was also said that she could realistically earn £15,000 per annum as a dog trainer and behaviourist, which meant that she didn't need the Duxbury fund. In terms of the younger claimant, the judge who was the judge was the Chancellor, Sir Julian Flo. He said that he doubted the payment of a sum to allow to switch to repayment mortgage could ever properly be described as maintenance, and that the liability to her ex-husband was contingent and in any event wouldn't be satisfied, wouldn't arise until 2034. So it was not a liability which she had or was likely to have in the foreseeable future within the meaning of the Act. When it came to the mirror will, the claimant's case was that Pamela, the court should infer that Pamela had revoked that mirror will, but Pamela had not said that she'd done that. She declined to answer questions about it in cross-examination, or declined to answer some questions about it in cross-examination, and the court accepted that. But the court said it was not prepared to accept that she revoked her mirror will, and that placed weight on her evidence that she would be guided by the deceased's wishes. And that was the evidence she gave in cross-examination. It also said that the deceased was under no legal obligation to support adult children, which was not controversial. He'd not assumed continuing responsibility to do so, and he had no obligations or responsibilities towards daughter within the meaning of the Act. The judge also found that the deceased's conduct after his marriage was not unreasonable. The claim that was run at trial was basically that he had acted unreasonably, particularly in relation to the younger daughter, Loretta, at both at the time and around the time that she was married, and around the time that she was leaving her husband and became pregnant with her first child, with her only child, sorry, her son. Essentially, what the deceased said is that, it was 6 of one, half of the, sorry, what the judge said was that it was 6 of one, half a dozen of the other, and at various points, nobody particularly covered themselves in glory, but he didn't think that the deceased had acted in an unreasonable way. And he reiterated towards the end of the judgment that the most important aspect, this is obviously apart from the fact that he'd said that the claimants hadn't established any needs, but the most important aspect that was after the 2008 gifts, the deceased was not prepared to offer further financial decisions, and the lifestyle choices which had been made by the claimants were not dependent on any expectation of financial benefit. And on that basis, he dismissed the claims. So I'm going to hand over to Barbara, who's going to talk about parents' obligation to maintain an adult child.
Thank you, Jordan. And excuse me, I haven't prepared detailed slides because partly I hate PowerPoint. I know that may not be a sufficient reason, but also I was mediating until midnight last night. But this is James Munby used the phrase in context of various aspects of the family court jurisdiction, the magnetic factor, and it's a phrase which can be apt in Inheritance Act claims as well, where there's a value judgment to be made on a range of facts and a range of different considerations as set out in Section 3 of the 1975 Act. Now, the Chancellor, Julian Flo, didn't use James Munby's magnetic factor phrase, but it's not inappropriate to apply it to Section 3(1)(d) of the Act here, which is obligations and responsibilities. And it forms a very important part both of the narrative and of the reasoning. And Jordan's taken you through the narrative, and we don't have time, but I'd sort of urge you to read the judgment because it sets out the letters that Tony wrote in his own words, how he saw his post-divorce relationship with his then adult daughters, and in particular how he saw his relationship with them changing from having been a father who'd provided, as it were, more than generously. And there's one in which he talks about, perhaps you don't realize how much it costs to provide the sort of life that you had. So there's a significant change in the relationship from being a very generous provider of what Jordan described as, and I would too, an upper middle class lifestyle, to saying, well, you can't expect that. And for quite cogent reasons, relating to the fact that he had parted with 50% of his worth on divorce from their mother, quite rightly, at the end of a very long marriage. That's what would be expected. And that his high-earning career had come to an end earlier than he would have wished. He was in his late 50s when he was CEO of Singer and Friedlander. And that at the time that he was writing, he was, again, in his late 50s, he wrote one autobiographical letter, explanatory autobiographical letter, which I'm sure wasn't intended to cause upset his daughters, but it clearly did. But he wrote that on his 60th birthday. So this is a man who's contemplating quite a long future life expectancy, and a future life expectancy in retirement, a retirement he intends to enjoy, to spend his money, and not really looking at mortality in the next decade. Now, unfortunately, he did develop the year after he made his will, he was diagnosed with a glioblastoma, which is what killed him 16 months later. But I think it's important, to put that into the lifespan context of what obligations he's contemplating at this critical stage, this pivotal stage, the key events, the leaving Singer and Friedlander, the divorce, the remarriage, the presentation of the significant financial gifts to his daughters, and the disclaimer of the future obligation to maintain. These are all very close in time, and they happen in his late 50s, around his 60th birthday, at a time when he's expecting average actuarial life expectancy. So against that background, the law, as we all know, since Ilott and Mitson, people have had views about adult children's claims, and I know some people think that Ilott has opened the door to more adult children's claims, and some people think that it's somewhat closed the door, or has shifted an approach to them to perhaps a less generous one. I'm not going to express a view about that, but again, looking very specifically at Section 3(1)(d) in the context of this case, the jurisprudence on it, it's quite, it's important as law, but it's also sort of shaping in how does law and society treat the expectations of any maintenance of adult children, and that in fact, specifically, not exclusively, but in some cases, adult daughters. And you may recall that when the very first Inheritance Act came into force back in the 1930s, the only non-disabled adults who qualified were unmarried daughters. There's been a degree of tenderness, as it were, towards daughters, but the world has very much changed from 1938. And our starting point here is a case called Re Jennings, which is an adult son. And Jennings is quite an old case, but it's still a very important one. It's from the 90s. Makes me feel very old to talk about cases in the 90s being old, but there it is. And Re Jennings, claimant in Re Jennings was a middle-aged man who'd done well for himself. He had his own building companies, which were solvent, had a comfortable lifestyle for himself and his family. He was somebody who'd really made good from a bit of a misery, certainly a financially miserable childhood in the 40s and 50s, because there'd been a divorce very early in his life between his parents, and a father who'd sort of just not maintained contact and not made any financial provision either. And at first instance, the father died. He asked for a reasonable provision to be made for his maintenance out of the father's estate, really his case was based on the parental failure to maintain during his childhood, which had come to an end some decades ago. And the case was successful at first instance, but not on appeal. And the important part was what the judge at first instance had said was that the Section 3(1)(d) obligations didn't need to exist at the time of death, but the Court of Appeal said no. In my judgment, that was wrong as a matter of law. Deceased's freedom of action to dispose of his property, and that if you remember, chimes with what's said in Adr and Mediation about respect for deceased wishes and freedom of testation. Deceased freedom of action to dispose of his property must be judged at the time of death. It's only then his current obligations and responsibilities that must be taken into account. Some undischarged responsibilities from the past may still be current. For example, a child might have given up a university place, excuse me, to nurse the deceased and now wish to take up that place. Moral obligation there would be both current and clear. But where the undischarged responsibility doesn't amount to an obligation present at the date of death, the statute doesn't require it to be taken into account. So that's pretty clear. And that, that does feed into the reasoning in Shearer. And then more recently, in 2004, and I say more recently, but still quite, it's a sort of, anything that's 17 years ago, that's kind of the difference between birth and incipient adulthood. It's a measurable period in which things can change. There's a case called Ree Myers, which is a James Mumby decision. And Ree Myers was an adult daughter, and where, I mean, the father, she was the daughter of an unhappy first marriage, and Mr. Myers had a very happy second marriage, and also he clearly had a knack for wealth generation. He died a very, very wealthy man through a hard work and private enterprise, but he'd taken quite a callous, certainly by our standards, very callous view of obligations on divorce from his first wife, and indeed the law had changed in the early 1970s to allow her to seek more generous provision, and he took a very, very resentful attitude towards that. And his attitude towards his daughter Beryl, who was about 60 or in her early 60s at the time of the claim, which was in 2004, so she had been born in the 40s, was very, to our perception, and James Mumby picks up on this in his judgment, was extraordinarily old-fashioned. There's a very, very graphic line in the judgment where James Mumby talks about how difficult it is for him as a judge born after the Second World War to, as it were, get inside the head of Mr. Myers, who was born before the First World War, and that's quite a graphic way of putting it. But when you read the judgment, I reread it for the purposes of this case, and just the facts, the things that Mr. Myers said about his daughter, they're, to modern eyes, they're really absolutely horrible, and rather cramped and very old-fashioned in the sense that she had a private education at a girls' school, but he had no serious academic or career aspirations for her and didn't encourage it. He basically, at one point he read some correspondence saying that what she really needed to have was to get married and have more sex. I mean, it's a horribly crude thing for a father to write about a daughter. And his general view of her was really unmitigatedly harsh. And by the time she came to claim, she had made a life for herself. She'd had both physical and some mental health difficulties, but she was really, it was like something out of a sort of 19th century opera. She was more or less living in a garret in Paris and her only possessions hanging in the cupboard. She was a teacher of English as a foreign language. But to get back to the legal point, at the beginning of the judgment in Ree Myers, James Mumby suggests a rather more pliable view of what a parent's obligations and responsibilities under Section 3(1)d can be than you get in Jennings. And as the Chancellor in Shearer picked up, that pliable view certainly hasn't entrenched itself as a statement of principle in subsequent cases. But what James Mumby said was that the deceased, Mr. Myers, owed the claimant the ordinary obligations of a father to an adult and fully emancipated daughter. He did not owe her any special obligations or have any particular responsibilities for her, unless arising out of what he knew or ought to have known of her financial, personal and medical circumstances at the time he made his last will, a topic I return to below. So, as I say, that's a more pliable view of the possibility of a moral obligation, some responsibility springing up out of even not just actual knowledge, but constructive knowledge of an adult child's circumstances. And that clearly is a view that formed his approach to the reasoning and to the outcome under which financial provision was made for Beryl Myers. But as I say, it's not become an entrenched statement of principle in subsequent cases, including ILOT, which, as we know, went to the Supreme Court. So Shearer does, it follows Jennings and focuses on what were the obligations and responsibilities at death. And no, there weren't any. There was a disclaimer. One of the cases that is also mentioned, and which I relied on to an extent in my submissions in Shearer, is that not of an actual parent-child relationship, but a quasi-parent-child relationship. And you may recall the case of Baines and Hedger. It's a very colourful case because it involved the estate of a woman who's quite a well-known sculptor and she'd lived in a ultra discreet, as in not publicly acknowledged, lesbian relationship with the claimant's mother for a very long time. And she had left her estate, her desire, which was fulfilled, was for the historic property she lived in to go to a heritage trust and to be used, to be available to the public as heritage property. And this claim was brought by her goddaughter, who at one stage had been married to Ken Russell. So there's a great deal of colour and history and culture in that case, which I don't have time to go into now. But in terms of law, that was a Section 11E claim. And for that, in the structure of the Inheritance Act, you also have to take into account of Section 3, subsection 4, which requires the court to look at the basis upon which somebody has assumed responsibility for maintenance. Nothing like that spelled out for parents, for the parent-child relationship. It's the parent-child status alone that confers eligibility, and Section 3(1)(d) is then ancillary to that as one of the Section 3 factors to be considered. And so although in Baines and Hedger, I mean, quite a lot of the reasoning is explicitly comparable, there's an explicit comparison to one of the adult-child cases, it isn't quite the same as looking at the adult-child responsibilities. And what the judge in our case, the Chancellor, said was that the most that could be drawn from Baines and Hedger in the case of an adult child, such as Juliet and Loretta, is that in considering Section 3(1)(d), the courts should consider to what extent, at the time of death, the deceased had assumed responsibility for the maintenance of the applicant. If the deceased has disclaimed responsibility, as Tony did in this case, that must be a relevant factual consideration militating against him having any obligations and responsibilities towards the claimants at the time of his death. On the basis of Jennings, any obligations or responsibilities he may have had towards them when they were teenagers or in their early 20s are irrelevant. So that's the Chancellor's words I'm quoting from, and I think that neatly sets into context those particular previous decisions I've mentioned, how they fed into the decision here, and what in it is likely to be relevant in future cases. Back to you, Jordan.
Thanks, Barbara. Yeah, so one of the things that we argued about, well, we didn't really argue about it, but somehow it seems that we argued about it when you look at the judgment. But one of the things that we looked at in this was the applicable standard of maintenance here, because of course...
We did argue about it.
Well, I don't know. Anyway, we did argue about it. One of the things that we looked at was the applicable standard of maintenance here, because of course, even in their current circumstances, the claimants were living a middle-class lifestyle. This was, you know, this was not, it was not a kind of Eilert and Mitzen case where they were, you know, they had been on benefits for years, they had no savings, etc., and both of them had a degree of capital, and one of them in particular had, you know, a job that was well above the national average in terms of her salary, and how that fed into the standard of maintenance. And of course, Section 1(2)(b) of the 1975 Act says that when you're looking at claims, it is maintenance that you're looking at, and that applies to all claims other than a claim brought by a former spouse or civil partner, including cohabitees. Now, Eilert and Mitzen basically summed up the position as we understood it, which is that the concept of maintenance is broad, but it can't extend to everything desirable for an applicant to have. It must import provision to meet everyday standards of living. That can include provision for housing, of course, but it's not designed to confer a kind of capital win. It's not possible if you're an applicant to which the maintenance standard applies to confer a kind of capital windfall on somebody. So then, re Dennis, this was cited with approval in Eilert and Mitzen as well. Brown, Wilkinson, Jay said in that, in my judgment, the word maintenance connotes only payments which directly or indirectly enable the applicant in the future to discharge the cost of his daily living at whatever standard of living is appropriate to him. And then, in reliance on that particular paragraph, in a 2008 case, Negus and Barhouse, which was a cohabitee case, Lord Justice Mummery said, I pause to say here, that was after citing that thing, that that statement, which has been acted on in many subsequent cases, does seem to me to allow regard to be had in awards under the 1975 Act to the fact that some people have a much more expensive or extravagant way of life than others. It is what is appropriate to that case, which means looking at what style of life the claimant was accustomed to live with the deceased during his lifetime. Now, there wasn't any argument that the standard of maintenance is different for different applicants, and there was no criticism from Pamela here that my clients had essentially led or were currently leading an extravagant lifestyle or anything like that, and it wasn't appropriate to look at their kind of middle-class lifestyle. The issue between us was in relation to the extent that you looked at the deceased's lifestyle as a marker of what was a standard of maintenance, what was the applicable standard of maintenance to the claimants. And that the judge said that Negus and Barhouse was not authority for the proposition that in adult child claims, you were to look at the lifestyle of the deceased, and he drew a distinction. He said the claimants, both adult children of the deceased, who had lived their own lives and made their own lifestyle decisions without any further financial assistance from Tony after the gifts in 2008. What is appropriate for their case is not comparable with what was appropriate in the case of a partner who'd shared the life of the deceased, as in the case of Negus and Barhouse. So essentially, I think what one draws from that is that in adult child cases, unless of course it's an adult child who's still living with the deceased, etc., and is dependent on the deceased for their day-to-day needs, it is of limited relevance, or indeed possibly no relevance, to look at the lifestyle which the deceased was enjoying before their death. What you're looking at, which you obviously would do in cohabitee cases where you're cohabiting with the deceased, what you're looking at is you're measuring that yardstick essentially without reference to that. Now, I'm sure, of course, that's as with almost everything in this, that's going to be fact specific and depend on the extent, how long ago that they left the deceased household and etc. But essentially, that idea that you say, oh, actually, the deceased was living, a very nice lifestyle, etc., and therefore you should judge an adult child's standard of maintenance with reference to deceased lifestyle was pretty much firmly rejected by the Chancellor. And with that, I'm going to hand over back to Barbara again to talk about Adr and mediation.
Thanks. I'm just going to add a footnote to what Jordan just said to put it into the very specific context of this case. What went home, as it were, on that particular aspect and led to what Jordan just explained to you was in particular the situation of Juliet, the older daughter, who she'd been married twice. She'd cohabited with both husbands in their respective matrimonial homes. And then it's pure coincidence that it was around the time of the date of death of her father. She and her second husband, who was a serving officer in the British Army, they had been living in MOD accommodation in Wiltshire. This is all in the judgments. I'm not telling you anything you wouldn't find out by reading. They were living in MOD accommodation, which I looked at on Google Street View. I don't have a military background, but it looks very institutional. It looks like a council estate without any or litter or graffiti. It's very spick and span, but a very ordinary sort of boxy semi and non-house and garden magazine type garden. And that had been the home where she and her second husband lived. There were child arrangements in place for the sons of his first marriage. She had her 2 daughters, so at times there were 6 of them in quite cramped accommodation. His job moved. The way it works with MOD accommodation apparently is that you have a sort of 12 months grace that you can stay in an MOD house after a job move, and after that either you move your household with it to MOD accommodation nearer to the new place of work, or you make other arrangements. Juliet's mother bought the house. It's called the Old Vicarage, and houses called the Old Vicarage and the Old Rectory, you can't pretend that they're anything other than quite desirable houses generally. I mean, I've yet to see any pictures of an old vicarage or an old rectory that isn't a reasonably spacious, attractive house. They're part of the sort of historic fabric of towns and, to an extent, villages around the country. And I wanted to, and I did make sure, and again, this is not giving anything away, that the sales particulars for the old vicarage at the time that Jennifer Shearer bought it were in the trial bundle, so everybody could see exactly what sort of property it was. And it clearly, the lifestyle that they enjoyed there as a joint household, firstly, it was successful as a joint household. Jennifer, Juliet's daughters, sometimes her stepsons as well. That had worked well as an arrangement. It was a very attractive place for them, particular benefits for Juliet's autistic daughter. But just, pictures tell 1,000 words. And when you look side by side at the MOD house on Google Street View and the sales particulars of the old vicarage, well, you can see an enormous difference. And what went home on the question of standard of maintenance was that Juliet accepted in cross-examination that neither her second husband, the army officer, or her first husband, who'd been an actor, neither of them could have provided her with the sort of house and standard of living in it that her mother was providing. And there was when I say her mother was providing, her mother bought the house, and Juliet's second husband's income some of that went towards outgoings of the house. So it wasn't all flowing from the mother. But that was the point, really, that a claim for provision at or reflecting a standard which you're enjoying thanks to another person, be it a parent or whoever, if that's sort of starkly different from the lifestyle you would be in, well, as I say, the comparison was neither of her spouses could have provided her with a comparable lifestyle, and that, as you can see in the judgment, quite influential on the judge's thinking. Anyway, and that actually also does feed into my short points on mediation. I've got 2 points to make, really. One, without going into any privileged material, it's obvious that there wasn't a successful mediation in this case, and there was a stark win-lose outcome in that both claims were dismissed. And of course, pre-trial, at the date of issue, there are a range of possible outcomes, as there always are, and that range expanded because there were 2 claimants. One possibility might have been some provision made for one, not for the other. So quite a lot of unknowns to contend with. And the fact that this judgment does show the claims dismissed, it's a stark outcome, is one. It's certainly, as many of you will know, I'm a very active mediator in this field, a lot of mediation experience, and it will feed into my future mediation experience, just as my past mediation experience somewhat fed into my preparation for the trial. That's the next thing I'll mention. And you may recall about a year ago, there's a case called Shearer and Sevier, which was a very, very different set of facts and circumstances, but again, an adult child's claim where there was a refusal to mediate. I know our colleague Hugh Cumber gave a webinar about it, which you can look up on our webinars page. But there was a lot of professional comment about the case. Now, I don't think any of us were professionally involved in it, but that was a case where a defendant had refused to mediate and was vindicated in their position, and the defendant was in person but assisted by a retired, quite senior solicitor experienced in another field of the law who'd come to help through a personal connection. And he wrote an article about it in one of the legal professional journals. And it is a topic that's worth reflecting on. If you're a defendant and you think there is a reasonable prospect that claims brought against an estate clearly by eligible applicants, there's no question, there are no ancillary issues like threshold eligibility, domicile, the sort of things that some of the mediations I do, there's often an intense focus on whether somebody's threshold eligible, but here's no question about it at all. So if you're a defendant in our position or a hypothetical comparable position, what's your attitude to the risk of saying, well, if I go to mediation, my reluctance to go to mediation is that I'm confident that I will prevail at trial. Of course, there's no certainty, and I think again I can freely say at the end of the trial I was not confident of the way that the judgment was going to go, and it's always, reading judges' faces and interjections is a dangerous game anyway. But I thought it was within the bounds of possibility that the judgment might have said something other than it did. I think any non-overconfident advocate is always going to ask themselves that question. I mean, it's an unpredictable jurisdiction, but there's a genuine question which was very much raised in the professional discussion about the Shearer and Sevier case, is if you go to mediation as a defendant, how does the process of mediation operate against your interests, in that the claimant, that the claimant won't go without something? If you're really, I mean, mediations, a lot of it is about risk assessment. If you're a defendant and you're really confident that your defence is going to succeed or has a very good chance of succeeding, your negotiating range should be starting at, well, your best case is that they go away and they pay all your costs to date, and your worst case is that you give them something to make them go away. I'm really, as you can hear, talking quite tentatively and speculatively because I don't know the answer to this. It is genuinely a very difficult decision. We all know that there are penalties for unreasonably refusing to mediate, but all I would say is that it's something to consider carefully if you are a defendant who has got a degree of confidence that they might completely defeat an adult child's claim, that you might turn out to be right, not to have negotiated a settlement which involved you paying something. And of course, every case is different, and in each case, part of the considerations that are going to be weighed up are things like recoverability of adverse costs, one's own, a defendant's personal financial situation. I mean, those are, as far as this or any case is concerned, confidential matters, but they're the sort of the topics to be thought about. My other point on mediation is that I think you can see it in the judgment, a lot of there's discussion of the proposal made, in particular by Juliet, the older daughter, because the starting point was she's currently living in a joint household with her mother. There's a pending divorce from the second husband. Her autistic child does place constraints and demands on her future lifestyle choices, all accepted. But they themselves, what they articulated in their updated evidence before the trial was that they foresaw the the splitting up of the joint household for reasons that were mutually, well, they were not nonsensical reasons on the face of it. They were to do with life changes and needs, evolving needs. So they sketched out the foreseeable split into two independent households, the mother's in returning to London, and daughter and her children remaining within striking distance of the autistic daughter's school. But what I felt wasn't what was explored in the evidence was the nitty-gritty of the choices that they had. How would that actually work out? They foresaw that the mother would put the old vicarage on the market when her older granddaughter had finished prep school, which would be next summer. But there was a lot of exploring in the evidence of what were the options, how were those options costed, were they acceptable in terms of lifestyle choices? And of course, cross-examination is a more formal, a more structured, and of course a more public process than the conversations I have in private sessions at mediation. But I was quite struck myself by the similarity between them. I would say, the subject matter, and yes, there's a difference in style of discourse, and but I don't regard myself, I'm not, those of you who know me professionally, I'm not an aggressive cross-examiner, and I in mediations, obviously, you have to maintain a kind of conversational rapport with everybody in order to make progress. So perhaps not so much difference of style as you might expect. But I think I do see, as I say, a lot of cross-fertilization. In my professional experience, vast majority of the inheritance cases that I am professionally involved with go to mediation and they end at mediation. But the two experiences, they do quite closely inform each other. And of course, mediation only happens because there is a threat, a shadow of litigation. So before I point out anything more, more pointing out the obvious, the final point on mediation is, of course, about publicity. And as I mentioned right at the beginning of this talk, there's been a lot of press coverage of this case, something entirely predictable to anybody with experience in this field. There's sort of factors of it that would the editors of the Times and the Daily Mail, have different their readership may be, they sort of know what their readers are interested in, and they have a certain approach to covering these cases. And I always keep track of them, not simply out of vanity in relation to any case I've been professionally involved with, but because I think public understanding of the law is important. It's something I'm generally very interested in, public discourse about the law, and this is all part of it. And more specifically, in my professional capacity, and very much as a mediator, I like to draw people's attention. I like to make people aware that one of the disadvantages of taking a case to trial in this day and age is the risk that you will be in the Daily Mail law reports, that the narrative is one that you can't control. Still less can you control the below the line comments, which frankly, the only sort of moderation that a newspaper will do of below the line comments is to take out possibly contempt of court, but to take out some death threats and perhaps extreme swear words or breach of confidentiality, but all sorts of really very intrusive, prurient, unpleasant comments. There they are, and they're on the internet forever, and particularly if your name is a bit unusual, they're going to come up on a Google search. And I'm speaking entirely personally, I'd move heaven and earth rather than myself be the subject of such an article. And I do talk to people at mediation a lot, so that at least they know that if they are going forward to trial, they go with their eyes open, that it's a risk, and that whoever thinks themselves to be on the side of virtue in any of these cases, there's a morally judgmental aspect. Now I'm talking about the public discourse, there's always a morally judgmental aspect. You can't guarantee who is going to be sort of presented as the more or the less heroic in these narratives. And it's a fact of life, and it's something I'm mentioning it now because I do stress it in my professional capacity when I'm talking to people. as an advisor and as a mediator. That's all I wanted to say about that. And there's just one final point to pick up. I'm sorry, I see it's 1 o'clock, so I'm going to be very quick. On procedure, something my instructing solicitor and I have touched on, and I think it may be a topic of wider interest. As we all know, Inheritance Act claims are Part 8 claims, what in the ancient days used to be called an originating summons. The point is they are not Part 7 claims. So there are no particulars of claim, and there's no process of disclosure and witness statements which tie in with pleadings and with the disclosure. There is a Part 8 claim, which is usually pretty sketchy and predictable in just laying out some basic facts and the basic threshold entitlement to claim. And then there's witness statements with exhibits. And I think, I'd be interested in people's views. I just really mention this for discussion. Would it be preferable to have an element of Part 7 procedure, in particular disclosure? Here, for example, we didn't have any disclosure of Jennifer Shearer, the first wife, mother, owner of the old vicarage, living with her daughter and her granddaughters. Clearly her circumstances are quite material to looking overall at the claims. And there's the joint household, but she also expressed a desire to help her younger daughter if she could, and certainly not to try and avoid treating her daughters unequally. Now, as it happened, it made no difference in the outcome that we didn't have disclosure of all of her financial circumstances and cross-examination on that. The cross-examination was based on really quite sketchy outline by her of what her situation was. So I merely leave it as a sort of thinking and perhaps future discussion point. Would it be to the advantage of litigants in the interest of the administration of justice to have a procedural change along those lines or not?
Well, and I think just to pick up on that, Barbara, on the disclosure point, last week Rosie and I spoke about the disclosure pilot, etc., and there is the note in that of Chief Master Marsh where he says that in appropriate cases the court should apply a tailored but similar procedure to disclosure in Part 8 claims as it applies.
That's the answer then.
Yeah, as it applies in Part 7 claims. It doesn't seem, from my experience anyway, that anybody's really taken that up with any degree of enthusiasm in 1975 Act claims. I'm not quite sure why that is, because, for example, it does seem to have been taken up with a much bigger degree of enthusiasm in executive removal, etc., which in lots of ways you'd think disclosure is often much less relevant to those type of claims.
Yeah.
But yes, I mean, it's definitely something to think about, isn't it?
We've just got one question, which is anonymous attendee. Was this a cost budgeted case? Is it possible to mention the overall financial cost of the parties of this dispute? Was it cost budgeted? No.
No, Part 8
doesn't require cost budgeting.
It doesn't require cost budgeting, and sometimes, of course, the master does of their own initiative. Doesn't necessarily, they can't force a cost budget, but they kind of push you into that kind of procedure. That didn't happen here.
Yep. And I don't think we can say anything about the overall costs, but you can, we'll leave you to speculate. You can look up the solicitors and counsel we are the counsel involved. You can look up the solicitors involved. It was a 5-day trial. There were I think there was one attended case management conference. What happened actually was that Mr. Shearer died and probate of his estate was issued, and then the Inheritance Act claim was made right at the end of the limitation period, and it would have come to trial last May but for the coronavirus pandemic, and it was then adjourned to this March. And in fact, Pam Shearer is a British citizen but lives in France, and she has a home in London as well, but it would have been extremely difficult for her to travel. My solicitor and I all attended the trial remotely. Day 1 was a reading day. Days 2 and 3 were evidence, and I cross-examined from the room and the chair where I'm sitting now. And Jordan and his clients and instructing solicitor were in court with the judge. And then I think on day 4, Loretta, and I hope she's fine, tested positive, and the entire trial went remote. So it went from being a hybrid trial to a remote trial. And I've done a lot of remote mediation, shorter hearings, but it was my first experience of a full-blown trial remote. And we don't have time to talk about that experience and its upsides and downsides. But I'm glad that there wasn't further delay, as there might otherwise been, in holding the trial, that we were able to go ahead, and that all the tech worked. Oh, second question, Polly Morgan. Apologies if you answered this. I wanted to ask further about the issue of the repayment mortgage. I would have expected the reduction in the claimant's outgoings by switching to an interest-only mortgage would be sufficient to constitute maintenance, as it goes directly to her living costs. Are you able to expand on why the court rejected that view, please? I think it's a question for you, Jordan.
Which I'm not going to answer, given the PCA,
Right.
application. You can look in the judgment, and you can see the basis on which there is an authority re-leach. I mean, that really is aged. It's early 80s authority, where mortgage repayments were kind of treated as maintenance. However, the judge said that they were very different circumstances, much older applicant, etc. And so he just said that he doubts very much. So it's not actually, that was something that Barbara and I did well, not argue, but we did make pretty detailed submissions on. That doesn't form a large part of the judge's reasoning, really. But you can see there, I think he's just saying that, unless, essentially, I think what you can extrapolate from what he's saying is that unless those payments free up income, essentially. So if you're saying that you have an income deficit because of your mortgage payments, then that may constitute maintenance if you're given a sum to alleviate that deficit. But in this case, there was no income deficit being argued, and so I think that was basically the basis of the distinction.
And then we've got a third question. The declaration by the deceased about no further payments to the daughters, how important was this in the outcome of the case? I would say, as I touched on that came close to being a magnetic factor, that he had disclaimed his obligation, any obligation. And I think the overall thing, and again, it's there in the judgment, is that it's not disputed that he was a generous father, generous and affluent father to them in childhood. They had an upbringing that he could afford, that many people couldn't, and that many people would envy. There's absolutely no question about that. But that since these, the series of momentous events, which is his appointment as CEO of Camp Thing, and then the arrival of the Icelanders, the unhappy departure. I mean, he later gave evidence to the Treasury Select Committee about that, and he was somebody who'd raised red flags, quite rightly, about these people. His judgment of them was shrewd and that of a man of integrity. But that's a slight digression. The momentous events are his career pivot through what happened at Singer and Friedlander, the divorce, the remarriage, the realization of the liquidity with which to give his daughters these 2008 gifts to get them onto the property ladder. The series of momentous events between sort of 2005, 2008, he turns 60, he writes this reflective autobiographical letter in 2008. And then his death in late 2017, just before his 69th birthday, and the initiation of the claim. So you've really got a decade in which his daughters have formed marriages. In Juliet's case, 2 sequential marriages. They've formed marriages, they've had children, they have bought properties on their own or jointly with partners. They've things in their lives have moved on. And this was, and I would say it's a very important feature of the decision, is that both of these adult women had made important lifestyle decisions to do with spouses and houses, if I can put it that way. And they'd made that without reference to any maintenance from their father. Then whatever they may have said about an expectation of being bailed out, they weren't. And both at different times encountered difficulties. And Juliet divorced from her first husband. In fact, it was her mother who helped her to extricate herself from tied financial affairs, in that case, to buy her out of a joint matrimonial home. And when Loretta's marriage ended, her son had just been born. Again, her father made it clear that he wasn't providing substantial financial support, and really, it's not just what he said, not just the declaration, but the action, the evolution of life events, I would say, is the backbone of this case.
Yes, and I think because we've had another one, which is essentially about, isn't the will enough? I think it's not, as Barbara says, it's not just that he said it, it's that he did it and acted on it over a long period of time. So, for example, you frequently see in 1975 Act claims that somebody will make their will and then they will have a letter saying, I've not made provision for X, Y, Z, because of X, Y, Z. And I think that this was of a different character, because it was done earlier. Somebody's asked if I could explain the grounds from which the claimant's seeking permission to appeal.
I know what you're going to say, but
the answer to that is I'm afraid not.
Dan.
Space.
We're all dying to know. Thank you very much, everybody who's attended. We have run a bit over time, but we've had a lot of interested questions. And as Jo's mentioned, a recording will be available. The judgment is on Bailey, and a lot of it is and this, I'm sure, is largely a professional audience, but it's as much readable narrative and reasoning which doesn't require legal training to discern. So as always, with my public understanding of the law hat on, I'd always encourage people to read the judgment for themselves. And thank you very much for coming.
Thank you, everyone.